our podcast. It comes to us courtesy of the Touro College Jacob D. Fuchsberg Law Center and the Touro Law Review. We're very pleased to have today as our invited guest, Lawrence A. Steckman, Esquire. Mr. Steckman is a practitioner in the area of securities, derivatives, and other areas. He's got an extensive list of litigation, settlement, arbitration. He's won numerous awards, been listed as a super lawyer, selected as a super lawyer, I believe 10 times. His AVVO award is superb, and we're pleased that he's been able to accomplish so much. He's also a prolific scholar, basically 50 publications that we know of. And so we invite him today. Mr. Steckman, welcome. Tell us a little bit more about your background if you wish, and then tell us whatever advice you may have for students who are seeking jobs and how they might use their own scholarly efforts in that job search. The floor is yours. Welcome.
Well, thank you. I'm glad to be able to address your audience. I am an attorney. I come to the law somewhat circuitous background. I'm a classical musician who was pursuing a doctorate in philosophy at Columbia when I took a class in the Columbia Law School and found it to be extremely interesting. And I decided to go to law school. At that time, I had not published previous to coming to Touro Law School, which at that time was located in Huntington, a 5-minute drive from my house in Cold Spring Harbor at that time. And in law school, I became very interested in producing publishable work. So while I was on the law review, the topics of the day were international terrorism, federal securities law, and constitutional law. And I decided that I would prepare pieces in each of those areas, the idea being to try and make a contribution to the literature in those areas, which I think would bring me to sort of the advice I might have to students who might be considering spending a little time writing. I can tell you that in the 2 interviews that I had before I decided which job I was going to take, the vast majority of my interviews focused on the work that I was then working on, specifically securities law, international terrorism, and con law. So what I would suggest to people if they're thinking about writing, number one, if you know what area you're interested in, would probably be a really good idea to write on the hot topic within your discipline, because when you get on an interview, people are going to probably want to talk to you about it, and you'll have researched, however many pages you will have read, particularly if you're arguing fairly novel theories. It's going to make you look like somebody who could make a real contribution to the practice area of the person who's interviewing you. And that was certainly the case. The first law firm I interviewed was the largest corporate and banking firm in the world. The second was the hottest litigation firm in New York at that time. And I think very much because of my writing, both made me offers in 3 days, and I canceled the rest of my interviews. So, I can't, certainly guarantee that would be what would occur were you to publish, but I can tell you that it does have a lot of advantages. Not only the fact that it might really help you get a job, but you learn the subject matter very, very differently when you're writing a law review article than even when you litigate it as part of your general practice. So for example, I've been practicing for 32 years. I'm publishing a law review with Touro on a case in my area on a theory that I'd never even heard of in 32 years of practice. So the bottom line is you learn things in a very different way when you're working on scholarly literature. Because when you're litigating, what you're really doing is just trying to win the thing. And usually that means looking up a couple of, circuit level cases, and whatever theory seems to fit best, you will articulate. And if the other side isn't particularly good at what they're doing, they're doing basically the same kind of thing. They're not trying to fully understand the jurisprudential reasons why you have a certain theory. And because that's not the focus, they're not really able frequently to come up with novel solutions to the novel arguments that you may need to present in order to win a case. So in my own view, it can be very helpful, in you becoming a better lawyer. It's very helpful for you in getting job interviews. And it's generally, I think, better helpful to your own development overall, because the more you understand about your practice area, the more it's going to allow you to look at other related practice areas and take information from them that you could potentially apply to your own practice area. Now, I speak primarily from the area of litigation because that's what I do. But I would imagine that you would have the same experience in any area where you're really having to develop solutions to problems, whether it's in the corporate sector, securities transactional work, or other areas. So, I can tell you the publication has been very helpful to me. And I've gotten several of my largest cases, which have been extremely interesting cases, because clients, very sophisticated ones, came in and said, by the way, I've read a dozen of your articles on this. And then they end up retaining me to try and get them the kind of result they want. So I can't guarantee that, you go write an article and, business pours in the doors. But I can tell you that some of the most interesting cases I've had did arise for me in exactly that way.
Well, it sounds like there is a number of kernels of advice. We may be getting some feedback. A number of kernels of advice within your presentation. Obviously, you're writing in an area that, one, you're interested in working in, and two, that is a novel topic in that area. But it also sounds to me like if you're going to make scholarship part of your job application, that you should be prepared to have a substantive discussion of it. Because it sounds like during your interviews, the partners interviewing you, they wanted to have a substantive discussion, which you were fully prepared to do. Would that be fair to say?
Well, I think that that's exactly right. And I will tell you that, when you go for an interview at least the kind of firms I was interested in, you're going to have 6, 7, 8 interviews. A lot of those are going to be by young associates, because that's what happens. And those young associates usually are bored with what they're doing and are happy to just be shooting the breeze with somebody. And if you're working on something which is really novel and something that they're interested in, all of a sudden you're in a very, very different position. So, for example, the hottest topic at the time I was applying for my first job in the securities area was the Ivan Boesky insider trading case. And the theory of the day was that he was going to get off because there was no way that he had a fiduciary duty, and you needed a fiduciary duty under the then Chiarella decision. And so everyone said the guy gets off. Well, that kind of infuriated me, because Ivan Boesky was moving the market by virtue of the size of his transactions. So I decided to develop a number of theories consistent with the legislative history that would allow him to be prosecuted successfully. And I did it by looking at the way the fiduciary concept was supposed to function under the securities laws. And then I argued you needed a functional definition in order that the fiduciary concept could serve its proper function. Ultimately, the SEC found out about the article I was writing, and they had people jumping in and on the phone with me, talking about this as an alternative to certain then current theories of insider trading. But the idea was to create something that was novel, but consistent with the laws that would let the laws do what they were meant to do. And that's going to be kind of interesting to somebody who's litigating under those very laws in transactions that are so large that the markets are being moved by virtue of it. The terrorism article, came right after the bombing of Libya in response to the bombing of the Label discotheque. That was an article arguing that international law, as it then exists in the area of international terrorism, could not sustain a legal condemnation of the United Nations because the conditions you need to have a legal rule, as opposed to a political or an ideological rule, did not exist. And I remember citing an unpublished manuscript from a professor at Columbia on that very topic. How do you distinguish legal rules from political or ideological rules? And ultimately create a defense of the United States and its actions in response to a terrorist act. So because that was front page news at the time and challenged the legal status of the rules themselves, it ended up being cited right after law school by Judge Weinstein in a decision, a major terrorist decision in the Eastern District, which was the first time any of my pieces were cited. But it was because, I found it to be, an extremely interesting area. It was very hot. And of course, I ended up spending a lot of time talking about it because people were interested in that topic. It wasn't something purely idiosyncratic. To me, this was the hot topic of the day. So if you can do that in whatever your practice area is or that you think it will be, you're going to be the one who's in there looking like you actually know what you can do. And that's going to be very helpful to the chances of securing the kind of position you want as a young associate.
Well, I find that very helpful to both editors and to writers. By the way, I have to laugh. My first circuit site, federal circuit site, was Judge Weinstein sitting by designation on the Second Circuit. And I assume it's one of my classmates as his clerk who cited my article. So I caught a break. But I think you make another very important point, because sometimes when you're an editor, whether you're a faculty editor or a journal editor, articles can make two sorts of contributions. Sometimes it's sort of the AOR approach of summarizing what's out there. And yes, that has value, but you're certainly not ignoring the need for that to lay in that foundation. But then you get to the real creative thinking where, I mean, novel doesn't mean anything. It's got to be tied to the background that you've taken time to construct, but it's the writer's own analysis that can be the most helpful, not only to get that first job, but then later in practice. That's what it sounds to me like you're suggesting.
Well, that is what I'm suggesting. Remember, I come out of a background in analytic philosophy, which is extremely interesting to somebody like me. I said, but it's really not going to be very helpful to people. And one of the reasons I switched to law is because I really wanted to have an impact, more than simply, finding something interesting in my own head. So though the articles I tend to write focus on problem areas where the courts disagree about something, and you try and offer some solution about it, the most important thing is you're making a very concrete contribution to the development of the jurisprudence in your practice area. And that means it's going to have really strong, big, concrete implications. And because the kind of cases that I have been involved in tend to be very large or involve novel financial instruments or areas where the law is extremely unsettled. For example, in the RICO statute, where the law is constantly changing, it's a very fertile ground for coming up with, creative solutions to very concrete problems that people are having. And, I'm not interested in writing, philosophy at this point, like publishing philosophy. I'm far more interested in coming up with creative solutions to areas where the law is unclear. Hopefully, by thinking about it a while, you hope to make a contribution to the law better, fair, and more reasonable. So I certainly would not deprecate in any way what you call the ALR approach, and I have published, a few works, that are really more, stating what the jurisprudence is. For example, I penned an article analyzing the loss causation, which is in securities land. That's like proximate causation applied to securities cases. Analyzing the developing jurisprudence of causation in securities cases in every federal circuit, analyzing every different theory of causation that was then being articulate in the cases. So, if you're going to then go litigate a case against somebody or other, and you have that background that you know every theory because you've already analyzed them all, you're going to be a much more effective litigator. And an article like that, for example, makes life a lot easier. If I'm litigating in the 10th Circuit, well, here's what the 10th Circuit has to say about the development, and you see the development of the theory. That's going to be an article that's probably going to be pretty helpful to somebody instead of having to jump on Westlaw and, start their researching it from the very beginning. So, I try and write only on things that are going to be helpful to people who are litigating the kind of things that, I find interesting and are my practice area.
Well, another aspect of what you're saying that I find interesting, it sounds to me like if you take the approach of proposing a solution in an area that you've become familiar with, in an area that you're interested in, first of all, I'm not sure a student writer should underestimate their ability to make a contribution. A good legal researcher and good legal writer, certainly, regardless of experience, can make a contribution. But then beyond that, I also find extremely interesting that as your practice has gotten more and more sophisticated and your writing has continued, it's helped you attract clients even later in your career, which is not something that I think is a particularly well understood phenomenon.
Well, I'll give you a couple of examples. I had a client walk in my office. He was one of the largest traders in synthetic derivatives in the world. He was going synthetic because his transactions were so large, they were moving the world's markets. He came in and said, I read your piece on loss causation. I had a case where someone who was a governor general of a country said, I read probably a dozen of your articles on the RICO statute. Similar. I've had similar experiences. Not everybody that I deal with is like that, but I represent a lot of attorneys, a lot of very sophisticated executives. Primarily in corporate and securities litigation, racketeering. So for some people, that's what they want. They want to see. They're not just interested in, I went to this big firm or I graduated from such and such a law school. They want to know what you can actually do. And then they come in and they ask you questions, as in those two cases, about the theories of the articles that you published. So, they want to know. And that particularly, that's true with attorneys that you may represent in litigation. So, but I think what you said is really true. You should not be intimidated to be creative in what you are finding. I mean, I'll give you an example. When I was in law school, I was writing onto the law review, and the topic had to do with attorney silence and its implications under the Sixth Amendment. Well, I researched it heavily, and I discovered that about half the cases went one way, half the cases went the other way. There was no way to factually distinguish the cases. So what did I end up writing about? It was clear to me, after reading the cases closely, that if the courts adopted a particular analytical language with certain semantic presuppositions, all the cases went one way. If you asked a different question in different language, all the cases went the other way. So I ended up arguing that this particular body of law, it wasn't the merits of the cases that were determining the outcomes. It was the semantic presuppositions of the analytical language that was being adopted by the courts very uncritically. Now, this is, in law school, you're not just writing and say, well, this court said this court said that. I mean, you're trying to really understand why are they coming out the way they are. And if you look at topics, particularly where the courts disagree with each other or come to outcomes that are not explainable in terms of the merits, there's probably something interesting going on that would make a subject of a good article. And ultimately, I ended up publishing that article. And it's been cited by commentators. I don't know if it's been cited by courts at this point, but I thought that was pretty interesting. And it wasn't a topic I really knew anything about when I started. But, it was kind of a fascinating, thing to notice in the cases, I thought, because the courts are all trying to say, well, we're reaching a conclusion based on the merits. But the truth is they weren't. They thought they were, but then you couldn't explain how all the cases broke down, half one way, half the other, and yet the analytical language was different between the two subsets of cases, which I thought was kind of interesting.
Yeah, I would agree. Do you think that judges, I mean, certainly judges who cite you in an opinion, an article that you've written, obviously they respect the article. Do you think when you're serving as an advocate that the judges you're before might be aware of the scholarship and on some level appreciative, whether they can articulate that or not?
That's a hard question. I mean, if you're in front of somebody like, like a Judge Rakoff, for example, who wrote the leading treatise that we all use or did use on the RICO statute, do I think it's likely that he recognized my name? Maybe. It's not the kind of thing that, you would say. And I also I wouldn't be comfortable citing my own work unless somebody cited me and then I cited the person citing me. Maybe then, I would do it. But the answer is I really just don't know how much scholarly literature the judges are really looking at. I will tell you one anecdote. I was litigating a case in New Jersey District Court, and I was retained as special RICO counsel it was an entertainment law case. And when I walked in the door, I happened to notice that the jury box filled up with people. So anyway, I argued the case, which thank God I won from the bench. They dismissed the thing. The judge's clerk came up to me and said, Mr. Steckman, I want to meet you, blah, blah, blah. Did you notice the jury box filled up? And I said, I did. He said, do you know who those people were? I said, no. He said, those are all the clerks of the court came in to hear you argue. I must say I was completely shocked. And I'm glad I didn't know that beforehand. It would have made me very nervous. But, apparently somebody did some research. I don't know if it was a judge or this law clerk just had a fascination with obscure RICO cases. But, I guess sometimes that does happen, but I have no idea how often it does. Yeah. And that was the only time I can say that something like that ever happened to me. But that is what happened.
Well, I can believe it. And actually, I do believe it can, at the very least, filter through at times. As a professor, sometimes with that title, you have a little bit of an advantage, or at least an opportunity. I had, there was a tort case in California, and 8 cases were consolidated. I was involved in sort of counsel on one of the briefs, and the court wanted to hear what I had to say. So they picked one lawyer from each side, and the California lawyers were not happy when the court admitted me pro hoc vici to come out there and represent, the 8 plaintiffs. But I attribute that to scholarship. I have no doubt that it inures to your benefit in the minds of judges, especially when you are talking about the more sophisticated issues, when they really do welcome the sensitive analysis and the in-depth analysis that's required to, in good faith, try to resolve some of these conflicts. There is no question that there are really legitimate conflicts based on good faith, but nonetheless differing approaches. I imagine resolving those sorts of conflicts or contributing to that brings you a lot of satisfaction.
Well, it does. I mean, I'm thinking I had this really fun case that arose out of a takeover of the largest engineering and energy company in Europe. And I was defending the chairman and CEO of the company, but there were all kinds of huge companies that were named, and they brought the takeover potential acquirer had brought RICO claims for various reasons in the state court in New York. So, everybody got up and argued, but then when it went over and we won, and then when it over to the appellate division, everybody said, Larry, you argue it for everybody. And these were some of the biggest companies in the world. And these are, the lawyers. So, I felt pretty good about that because these guys recognized, there's a limited amount of time when you're on an appeal, obviously. But I ended up arguing. I became very close friends with the chairman and CEO as a direct result of knocking out a RICO claims against them and ultimately saving the company from being acquired by a well-known takeover person. So, it's good for your interview. It's good for your presentation before courts. It's good before your peers. And, hopefully it generates clients and it gives you a level of confidence, that when something walks in the door in your practice area, you not only know the basic law, you know why it's there. And sometimes you have to be creative in order to find a way to win a case. But it's very hard to be creative if you don't really have a strong substantive background, not only in your own practice area and in procedure, but in related areas, which helps you to analogize and to come up with solutions that, hopefully are going to work, which is good for your client, and it's obviously good for you.
Well, I think that's really an excellent summary. I mean, I'm very pleased that you recap the timeline during which it could be helpful from student through all the way through a very experienced practitioner, and also articulated the requirements necessary to be successful in terms of the level of research and preparation required. I do want to thank you for joining us. It's always my very sad duty to bring these to a close, as that's the most unfortunate thing the moderator has to do. But I do hope that this is a type of podcast that can be listened to several times, get the summary of advice, get the explanation of the advice, and great thanks to Mr. Lawrence A. Steckman, certainly a noted and practitioner and scholar who makes significant contribution. Thank you again for appearing on our podcast.
My pleasure.
Thank you so much. And I've been your moderator, Professor Peter Zabłocki here at Touro, and I look forward to our next podcast. Thank you again.
Take care.